Hello and welcome to this competition law podcast in which I'm joined by Benoit Keane and Helen Bignell. Helen's a senior associate in EU and UK competition law at Hogan Lovells, and Ben also specialises in EU competition law and is a senior associate at Sidley Austin based in Brussels. Both Helen and Ben have considerable experience in dealing with the application of competition rules to the sports sector, and they've acted for a number of sports governing bodies and organisations on competition law issues before the EU Commission and the European courts. So perhaps the obvious question to start with then is whether sport's any different from any other sector in the economy when it comes to applying competition rules.
Well, indeed, competition rules apply to sports companies in the same way. For example, if clubs get together and try and price fix the value of replica shirts, they could be subject to a cartel investigation.
Having said that, sport is certainly special and has unique characteristics which need to be taken into account.
Indeed, these are taken into account in two specific areas. The first area is in the commercial sphere. For example, clubs, leagues and sports competition organisers have to cooperate to create a sports product. The FA Premier League, for example, requires 20 independent clubs to form a league in order to have a product, the media rights, to sell to the consumer. Without this cooperation, there will be no product. And this contrasts with the position of other economic sectors where companies would not usually cooperate with competitors to create a product.
Indeed, sport is even more peculiar because teams depend on strong competitors in order to make the event an exciting one for viewers. And then there's the other side that we need to consider, the regulatory sphere. Governing bodies for sports have to oversee the enforcement of regulatory rules, such as anti-doping rules. Competition rules can apply to the manner in which they exercise these regulatory roles.
So we're not really talking here about the competition in terms of the sport that's actually played. We're talking about kind of ancillary things that go along with sporting events, like you say, the replica shirts and the merchandising. We're not talking about the sport itself.
Absolutely. This competition law, in the economic sense, should not be confused with the competition rules of sporting events. The two are very different, and unfortunately, we don't get involved enough with the sporting rules, but the competition rules of the economic sector is what is at issue.
And Ben, you started off there talking about the commercial sphere. How do competition rules apply to the sale of, say, media rights in sport?
Well, competition law has been applied by the European Commission in a number of cases concerning the collective sale of media rights. The leading case concerns the UEFA's Champions League, but there have also been important decisions in relation to Formula 1, the FA Premier League and the German Bundesliga.
As we know, Article 1011 of the Treaty on the Functioning of the EU prohibits an agreement between undertakings or by an association of undertakings, which has as its object or effect the prevention, restriction or distortion of competition, and which affects trade between EU member states. Clubs are undertakings for the purpose of Article 101 as they carry out economic activities when selling media rights to television broadcasters. Football leagues or national associations which sell media rights are therefore considered as associations of undertakings.
So, for example, in the FA Premier League case, the Commission stated that the clubs were undertakings and therefore the Premier League was an association of undertakings for the purpose of selling media rights to broadcasters.
Isn't it then arguable that clubs are actually acting as a single entity when it comes to selling rights through a league and therefore aren't subject to any competition rules?
This is a very interesting question. There must be an agreement between at least two undertakings or between an association of undertakings for the competition rules to apply. The undertakings in question must be independent of each other. So, for example, an agreement between a parent company and its subsidiary is not caught under Article 101, as these are treated as being part of the same undertaking for the purposes of competition law.
The argument has been made that leagues are similar to parent-subsidiary situations because the clubs need each other in order to be able to create the competition in question. The European Commission took the view that each club is an independent owner of media rights in the league, and therefore the league is an association of undertakings for this purpose. However, the issue has not been analysed in much detail at the European level.
Has there been any discussion in other jurisdictions on this issue? Presumably there are sporting competitions elsewhere in the world.
Indeed, in the United States, this very issue was the subject of a case before the US Supreme Court, in a case involving the National Football League, which organises the major American football competition, and a company called American Needle. The case concerned an agreement by the NFL clubs to jointly sell their intellectual property rights for trademarks and badges to be used on clothes through a single company linked to the NFL. The NFL entity then entered into a 10-year exclusive licensing agreement with the clothes company Reebok for the sale of rights of club logos on baseball caps and T-shirts. American Needle, which is a competitor of Reebok, brought an action before the court seeking the annulment of this agreement on the basis that it was anti-competitive under US antitrust laws.
And so, in its defence, the NFL argued that they were acting as a single entity and the rules did not apply. However, the US Supreme Court rejected this view. It considered that the NFL teams do not possess either the unitary decision-making quality or the single aggregation of economic power characteristic of independent action, to quote them. The US Supreme Court also stated that to a company making baseball caps, the NFL teams are potentially competing suppliers of valuable trademarks. As a result, decisions by NFL teams to license their separately owned trademarks collectively and to only one vendor are decisions that deprive the marketplace of independent centres of decision-making, according to the US Supreme Court.
In the EU and US, there seems broad consensus now that when selling the rights through leagues, the collaboration between the clubs and leagues is caught by antitrust rules and is not exempt on the basis that it is just conduct of a single entity.
So if the league's agreements are caught under Article 101, then how are the rights then sold in line with competition rules?
Well, as you may be aware, under Article 101(3, an agreement will be considered as being justified where the benefits of the agreement for consumers offsets any detrimental effects on trade or competition that it may have. The Commission, in its decisions, has set out a number of elements it will take into consideration when making an assessment of the benefits of joint selling. So, for example, the Commission considers that joint selling brings a benefit to broadcasters and ultimately consumers because it provides broadcasters with a single point of sale. Instead of broadcasters having to deal with 20 clubs individually in a league, they are able to go to one seller. This enables the broadcasters to buy up the rights for a scheduled season and to plan their schedule around the rights that they have acquired. It means that they're not reliant on one single club's performance. And furthermore, it enables the organiser to control the branding and production of matches and to ensure that the broadcasting is of a high standard. For example, we can all recognise an FA Premier League or a UEFA Champions League match from the moment the opening credits start.
There are two other important points to note. The first is the 3-year exclusivity point. The rights should be sold for limited periods of time, generally in 3-year slots. This prevents the market from being foreclosed for a long period. The other is that rights are sold in packages, which means that a broadcaster does not have to buy up all the rights. This enables a number of broadcasters, in particular smaller broadcasters, to compete for the rights as they may have the finances to bid for one of the packages of rights, even if they can't buy all of them.
So does that mean all forms of collaboration are likely to be exempted?
Not necessarily. It will depend on the activity concerned. In areas where coordination is required, such as cooperation to create the broadcast of matches to a league, joint selling is clearly justified. However, in other areas this may not be the case.
So have competition rules been applied in other commercial areas in sport then?
Indeed. Competition rules have also been applied to the area of ticketing, for example. In 1999, the European Commission found that the ticketing sales system of the French organising committee for the FIFA World Cup held in France had infringed EU competition rules. The Commission considered that the ticketing system which favoured applicants able to provide an address in France was discriminatory and in breach of the organising committee's dominant position in the market for tickets to the FIFA World Cup. The Commission only imposed a symbolic fine of €1,000 upon the organising committee, but the decision did create a precedent in the field of ticket sales for major sports events.
So if we turn now to the regulatory angle, it would seem strange to many people that competition law is applied in this sphere, as regulators aren't really carrying out an economic activity but are just really overseeing the market, isn't it right?
This is indeed the constant debate in this sector. On the one hand, the competition regulators say that they have the right to examine the conduct of sports governing bodies under competition law.
And then, on the other hand, sports governing bodies consider that sports issues are best dealt with by governing bodies, and that competition rules are not really appropriate for examining whether decisions on anti-doping or betting or financial management are appropriate.
Clarification on the manner in which competition law applies to the regulatory powers of sports organisations came in a case far from the world of sport. In Wouters, the ECJ considered the application of competition law to the regulatory rules of the Dutch Bar Association of Lawyers, which prevented accountants in the Netherlands entering into professional relationships with lawyers. The judgment is very relevant to all self-regulating professions, including sport, in how they set their rules and regulations.
In that case, the Court of Justice held that the rules and regulations set by the professional regulator amounted to a decision by an association of undertakings. It rejected the notion that the bar was carrying out social functions, as it had not been conferred with any power by the state. However, the Court of Justice considered that, and I quote, "Not every agreement between undertakings or every decision of an association of undertakings which restricts the freedom of action of the parties or of one of them necessarily falls within the prohibition laid down in Article 1011 of the treaty." It went on to find that account had to be taken of the objectives of the decision and whether the consequential effects restrictive of competition are inherent in the pursuit of those objectives. The ECJ found that although the bar rules were restrictive, they were inherent to the objective of ensuring the proper objective of legal practice in the Netherlands by ensuring the independence of lawyers and preventing conflicts of interests.
So regulatory rules can be scrutinised under competition law then. Has this been applied to the sports sector?
In fact, it did not take long for the European Commission to see the relevance of this case to the sports sector. The Commission followed a similar approach in a competition case concerning a restriction on clubs owned by the same body in a sports tournament. In the ENIC case, the Commission assessed the compatibility of the European football governing body's rules on the independence of clubs participating in UEFA tournaments with competition rules. The Uefa Regulations prevented any individual or company from owning more than one club that participates in a UEFA tournament, such as UEFA Champions League.
The investigation by the Commission arose when ENIC, which is a company that has controlling interests in a number of clubs in Europe, such as Glasgow Rangers, FC Basel in Switzerland, and AEK Athens in Greece. The UEFA rules meant that only one of ENIC's teams was able to participate in a UEFA tournament in the event that they qualified for that event. The matter had already been addressed by the Sports Tribunal, which comprehensively rejected the complaint. The parties, when they went to the Commission, were therefore seeking another bite of the cherry, shall we say.
The Commission considered whether the object or effect of the rule was to restrict competition. It held that the object of the rule on club ownership was to ensure that there was a clean competition and to protect the integrity of the sport. Its object could not, therefore, be considered as anti-competitive in nature. The Commission then considered whether the effect of the rule was anti-competitive in nature. The Commission recalled the judgment of the European Court of Justice in Wouters and said that where a rule is inherent to a legitimate objective and proportionate in the manner in which it achieves that objective, it should not be considered anti-competitive.
The Commission then went on to state that the contested rule, and I quote, seems to be inherent to the very existence of the UEFA clubs' competitions and does not lead to a limitation on the freedom of action of clubs and investors that goes beyond what is necessary to ensure its legitimate aim of protecting the uncertainty of the results and giving the public the right perception as to the integrity of the UEFA competitions with a view to their proper functioning.
So does that same rationale also apply to regulatory rules that don't really concern commercial interests but are really more about sporting integrity and things like that?
While competition law was considered to apply to the more commercial elements of the regulatory regime, it had been generally assumed that other regulatory aspects which go to the heart of the rules and ethics of the sport did not fall, as these were pure sporting matters that fell completely outside the scope of competition law. So maybe it's helpful to consider the Mecca Medina case here. In that case, there were two swimmers who challenged the anti-doping rules of the Swimming Federation on the basis that they restricted the ability to work and thereby compete on the market. This raised the question whether rules going to the heart of the sport's integrity, such as anti-doping rules, can be scrutinised under competition law.
The facts of the case are interesting. Mecca Medina and Machen were both caught with excessive amounts of nandrolone in their blood systems after a swimming contest. They were subsequently banned for 4 years by the Sporting Federation responsible. They challenged this before the Sports Tribunal, which upheld the ban but reduced the duration to 2 years to take account of some new scientific evidence that the swimmers presented. Nonetheless, the swimmers then brought their complaint to the European Commission, saying that the anti-doping rules were in breach of competition law. Initially, the European Commission threw out the complaint, saying that the anti-doping rules did not relate to an economic activity and therefore fell outside the scope of European rules entirely. The Commission considered that even if the competition rules applied, the restrictive elements of anti-doping rules were inherent to achieving legitimate objectives and would not be prohibited. The Commission stated that it was not the Commission's job to take the place of sporting bodies when it comes to choosing the approach they feel is best suited to combating doping. So initially it seemed, in any event, the Commission was not interested in getting involved in anti-doping matters from a competition perspective.
The swimmers appealed this decision. The General Court, then the Court of First Instance, considered that anti-doping rules were pure sporting rules that did not relate to an economic activity and therefore fell outside the scope of EU law entirely. The General Court even criticised the Commission for assessing the rules under competition law. While competition law was considered to apply to the more commercial elements of the regulatory regime, it had been generally assumed that competition law did not apply to other regulatory aspects which go to the heart of the rules and ethics of sport. This was because they were pure sporting matters that fell completely outside the scope of EU law.
The swimmers, who must be long-distance swimmers, appealed this judgment before the European Court of Justice. The Advocate General in the case, who advises the ECJ, took the unusual step of giving his non-binding opinion to the court on the same day as the hearing of the case. He rejected the appeal entirely, saying that anti-doping matters did not relate to economic matters and therefore fell outside the scope of European law entirely.
Then, just as happens in sport, something quite unexpected happened and the game completely changed. Anti-doping rules, the ECJ held, were subject to competition rules as they related to the economic activity of carrying out professional sport. The ECJ declared that anti-doping rules could have adverse effects on competition due to the penal nature of anti-doping rules and the magnitude of the sanctions applicable if the penalties were ultimately proved to be unjustified. This could result in an athlete's unwarranted exclusion from sporting events and thus an impairment of the conditions under which the activity in question is conducted. The ECJ concluded that, and to quote, in order not to be covered by the prohibition laid down by Article 101(1) of the TFEU, the restrictions thus imposed by those rules must be limited to what is necessary to ensure the proper conduct of competitive sport.
So does this mean then that anti-doping and other sports regulations infringe competition rules?
No, far from it actually. An agreement must still have as its object or effect the restriction or distortion of competition. If it has no such purpose or effect, it is not caught by the competition rules.
In the Mecca Medina case, the court went on to find that anti-doping rules pursue legitimate objectives, namely to protect the integrity of sports competitions and the health of the professional swimmers.
And so, to determine whether the anti-doping rules are proportionate, the Court of Justice says that two matters must be assessed. Firstly, the level of the drug, and secondly, the duration of the sanction. In the Mecca Medina case, the Court of Justice concluded by assessing whether, as a matter of competition law, the level of nandrolone set by the Sport Authority was appropriate, and even indicated that the duration of the ban in certain circumstances may be too long.
The Mecca Medina judgment has, however, come into some criticism, as the court did not really assess whether the regulatory authorities were acting as commercial entities in setting the anti-doping rules. This was assumed in the facts of the case. This issue has come up in another anti-doping case brought subsequently by a professional tennis player against sanctions imposed on him by the ATP. The player was found to have taken a banned substance by accident during a tennis tournament. Notwithstanding this, he received a ban for a period of time. The player had appealed this sanction before the Sports Tribunal, but lost that appeal. He then lodged a complaint with the European Commission against not only the sanction imposed upon him, but also the findings of the Sports Tribunal and the anti-doping regulations of the World Anti-Doping Agency, WADA, claiming that the anti-doping regulations and sanctions were anti-competitive.
The complainant argued, for example, that WADA is an undertaking because it provides anti-doping services. The Commission, however, was unconvinced. It noted that WADA adopted rules on anti-doping and therefore its rules is comparable to a legislator or, to quote it, a police for sport. It was therefore improbable that the activities of WADA could be considered as being economic in nature. The Commission also dismissed the complainant's assertion that the Sports Tribunal is an undertaking for the purposes of competition law, just because it provides services in the form of the resolution of conflicts. In the Commission's view, the role of the Sports Tribunal was comparable that to a normal court or tribunal. The Commission considered that the activity of the Sports Tribunal of giving judgments, as well as the functions of administering this activity, were not therefore economic in nature. In contrast to those findings, the Commission found that the ATP's activities, the tennis organiser, in organising tournaments and selling the rights to those events through its stake in another company, could actually constitute economic activities. It considered that the anti-doping rules which the ATP applied were directly linked to the organisation of its sporting events, and as such they were required to protect the integrity of the competition, the health of the participants and the equality of chances. The Commission therefore found that the ATP was in fact an undertaking subject to competition rules.
This analysis is interesting because on the one hand the Commission recognises that sports organisations such as WADA may fall outside the competition rules, and on the other it suggests that the mere fact that a regulator carries out some commercial activities may mean its regulatory functions when exercising those activities are also scrutinised. The criticism is that regulators should only be subject to competition rules when the rules relate to commercial rather than integrity and sporting issues.
In any event, it seems that for the time being, anti-doping rules and regulations of this nature could face scrutiny under competition rules.
So what about sporting situations where governing bodies regulate sectors that don't come within their area of sport necessarily?
The fact that sports governing bodies regulate areas not strictly speaking falling into their jurisdiction does not mean that they're not entitled to regulate this area.
Indeed, this issue arose in the Piau case, which concerned a competition complaint before the European Commission, which was brought by a sports agent against the regulations adopted by the worldwide football governing body FIFA. The Commission considered that the regulations were not inherent to FIFA's objectives, as the rules regulated a profession to which FIFA had no direct interest, i.e. it regulated sports agents rather than the activities of sports players. However, the Commission concluded that the restriction could nonetheless be exempted under Article 101(3). Consequently, the Commission rejected Mr Piau's complaint against FIFA's player agents regulations. Mr Piau then challenged this decision of the Commission before the European General Court.
The European General Court agreed with the Commission's analysis that FIFA constituted an association of undertakings for the purpose of competition law. It considered that FIFA was composed of national associations which carried out economic activities through the sale of rights to international matches and represented clubs which pursued economic activities. The European General Court considered that FIFA's players' agents rules amounted to a decision by an association of undertakings, and as the rules applied across all EU member states, it was considered to have an effect on trade between member states. The European General Court also agreed that the regulation of sports agents fell outside the inherent activities of a sports regulator, as it was not directly related to its sphere of activity.
However, the European General Court agreed with the Commission's finding that the licence system for sports agents seeks to protect players and clubs, and takes account of the risks incurred by players who have relatively short careers in the event of poorly negotiated transfers by agents. The European General Court also considered that the potential sanctions for infringements of the rules were not open to criticism and were not manifestly excessive. The conclusion from the Piau judgment is that rules which are not necessarily inherent to a sport but which may be beneficial to players and actors in the profession may be exempted under Article 101(3) from the competition rules.
So what happens then where there's a conflict between the sports governing bodies' regulatory rules and their commercial interests?
Competition rules require sports federations to act in a non-discriminatory manner. However, there is no prohibition on sports federations from exercising commercial as well as regulatory functions, as long as they don't use their regulatory powers to favour their own interests in an anti-competitive manner.
This issue was addressed in a recent case called Moto concerning Greek motorsport. Under Greek law at the time, all motorcycling sport events organised in Greece had to be authorised by the Greek minister following the consent of ELPA, the Greek Motorsport Federation, which is a member of the International Federation for Motorcycling. In February 2000, an independent motorcycling organiser called Moto applied for authorisation to hold a number of motorcycling events. The application was sent to ELPA so that it could give its consent. By August 2000, and after some correspondence on the matter, the authorisation was still not forthcoming from ELPA. Consequently, Moto withdrew its application and brought an action against the Greek state, arguing that the Greek law infringed, amongst other matters, European competition law, and in particular Articles 102 and 106.
Article 106.1 prevents member states which confer special or exclusive rights upon undertakings from maintaining or enacting any legislation in breach of the competition rules. This provision prevents EU member states from conferring exclusive or special rights upon companies, which give rise to the risk that they will then abuse a dominant position. The Court of Justice was particularly concerned that there was no form of appeal to the decisions of the Greek Motorcycling Authority under Greek national law. It found that the law created a risk that the Greek Motorsport Federation would favour its own events.
Although the case related to the national law, giving the Federation the power to regulate the sector rather than its own application of those rules, it does indicate that federations must act in an impartial manner.
So Ben and Helen, what developments do you think there are going to be in this area? Do you think there'll ever be an exemption from sport for? Do you think there'll ever be an exemption for sport from competition rules?
In the commercial sphere, there is a major case relating to the Premier League before the Court of Justice regarding the validity of exclusive rights contracts under European competition and free movement rules. This could have major implications for the audiovisual market as a whole.
And then in the regulatory sphere, we are likely to see the specific nature of sport to be taken to a And then in the regulatory sphere, we are likely to see the specific nature of sport to be taken into account to a greater degree as a result of the new provision on sport in the Lisbon Treaty. So while there may be no future exemption for sport, we may see a greater awareness of the specific characteristics of sport in the future in competition law cases.